Thank you very much, Mr. Speaker. As is traditional, I would like to thank the Secretary of State for advance sight of his statement. In that, as he said himself, the judgment in the Dillon case is a complex judgment. We on these benches certainly agree. I suspect, Mr. Speaker, this judgment will be pored over and indeed argued over at considerable length, not least in the other place should Labour's benighted Troubles Bill ever make it there. Just a point on immunity and the concept that lay behind the Conservatives' 2023 Legacy Act. I served on the Defence Select Committee under the member for New Forest, an excellent chairman, when in 2017 we produced an extremely detailed report on this complex issue. I think, in fairness, the Secretary of State has read that report. And what was proposed by the Select Committee is very akin to what the Legacy Act turned out to be. And that, in turn, was based on the South African Truth and Reconciliation Commission. We never legislated for absolute immunity for anybody. We legislated for conditional immunity, so that if someone who was involved in a Troubles-related fatality came forward to give evidence to the ICRIA Commission, and I'll return to them in a moment, was judged by the Commission to have fully cooperated with them, for instance, in revealing the burial place of one of the so-called disappeared, if the Commission believed that that individual had genuinely cooperated in good faith, then they would be granted immunity. But if not, if they felt that person was lying or dissembling or trying to hide something, they could still recommend that a prosecution went ahead. So, contrary to the government's position, the Legacy Act and the Commission, the ICRIA Commission, had established only ever allowed for conditional immunity. And it's important to put that on the record this morning. I have three specific questions to the Secretary of State about his statement, which are: one, can you say a bit more about the relationship between the Dillon judgment and the Windsor framework? He touched on it, but can he expand? Two, as he knows, many of the cases brought against veterans were funded by legal aid in Northern Ireland. He referred very briefly to the implications for legal aid. Can you say something more about that? And thirdly, we heard at Business Questions a few minutes ago that the Armed Forces Bill will be returning to the House for its committee stage on the 2nd of June. I was quite involved with that. When does the government plan to bring the Troubles Bill, which under the programme motion has 2 days for committee and remaining stages, back to the floor of the Commons? Perhaps he could answer that specifically. Now, I'm sad to say that Labour have been absolutely cynical today. I would humbly remind the Secretary of State that when we debated and voted on the related remedial order back on the 21st of January, almost a third of the Labour Parliamentary Party abstained, famously including the Armed Forces Minister himself, who, as we all know, is otherwise occupied today, and even the current Prime Minister abstained. He blew the whistle and sent his troops over the top to vote for this benighted bill that he didn't have the courage to vote for himself. Which brings me to encapsulate exactly what's going on today. While this government prepares to tear itself to pieces over a mixture of post-electoral fear and vaunted ambition, what is the Labour Party's absolute priority this morning? It is to advance legislation to facilitate the prosecution of brave Northern Ireland veterans, many of whom gave their lives to uphold the rule of law in Northern Ireland. In essence, to defend all of this around us today. That sums the Labour Party up. They've clearly chosen today as a not-so-good day to bury bad news, and the very bad news is, despite all their protestations to the contrary, they would rather help Sinn Féin chase those who fought for their country. The public will see this for what it is, not a complex legal treatise. It is a disgrace.
Well, I say to the honourable gentleman, I can agree with him when he describes the judgment as being a complex one, and he is absolutely right about that. I would just make clear that the protected disclosure relating to the legation of remains of those who'd been murdered by the IRA and in almost all cases buried in the Republic of Ireland, covered by separate arrangements that were introduced when the ICLVR was created. And that had support right across Northern Ireland because people rightly judged the most important thing was to enable families to be reunited with the remains of their loved ones. And there are sadly 4 individuals whose remains have not yet been found. He talks about the conditional immunity scheme, but the fact remains that if a terrorist who committed one of many horrendous crimes, some of which are being investigated at the moment, at the M62 coach bombing, what happened at Warren Point, the Kingsmill massacre, if they came to the Commission and told the full truth, what the government's legislation, the last government's legislation said that the Commission must, not may, but must grant them immunity from prosecution.
If they believe they cooperate.
And well, I'm afraid it's not a question of nuance, because the reason why,
Sorry, Secretary of State. Minister, Shadow Minister, you asked the questions. Please allow the Secretary of State to answer without interruption.
Thank you, Mr. Speaker. The reason why the immunity provisions had no support from any of the political parties in Northern Ireland, and he knows that, had no support from victims and survivors organisations in Northern Ireland, and he knows that too, is because people were outraged by the suggestion that terrorists who committed appalling crimes should be able to walk away scot-free because of those immunity provisions. And he also has to recognise that immunity remains incompatible with our human rights obligations. Now, on the 3 specific questions he asked, the first about the interrelationship between the Dillon judgment and the Windsor Framework, well, clearly a very important part of the judgment is to do with the Windsor Framework. In essence, the issue before the Supreme Court was this: has Article 2 of the Windsor Framework been correctly interpreted by the courts in Northern Ireland when they decided to disapply the immunity provisions and in effect struck them down? And what the court said very clearly was that that was incorrect. And the reason the government brought the appeal was because although we disagree with immunity as a matter of principle, and it never existed, that judgment of the courts in Northern Ireland raised a much bigger question which could be interpreted in other ways in respect of other policies. And you will have seen some of the issues to do with immigration. So that is why the government brought the appeal, and we have now got clarity that Article 2 applies to certain things, but it is not capable of the broad interpretation that the Northern Ireland courts had given to it. Secondly, on the subject of legal aid, that is a matter for the Northern Ireland Executive. It is their responsibility. On the Troubles Bill, as he will know, it is a carryover bill for this session. The committee stage will come early in this new session. I don't accept what he said about it, for the very simple reason that the basis, as he well knows, the basis on which any decisions are taken about prosecutions has not changed and will not change under the legislation that the government is bringing before the House. And everybody recognises that with the passage of time and the facts demonstrated, that the chance of further future prosecutions is rapidly diminishing for reasons all of us understand. And I would also remind him that any decisions about prosecutions are taken independently by independent prosecuting authorities.